Atwater v. City of Lago Vista, Supreme Court, 2001. Justice Souter delivered the opinion of the court. The question is whether the Fourth Amendment forbids a warrantless arrest for a minor criminal offense, such as a misdemeanor seatbelt violation punishable only by a fine. We hold that it does not. 1. In Texas, if a car is equipped with safety belts, a front seat passenger must wear one, and the driver must secure any small child riding in the front. Violation of either provision is a misdemeanor punishable by a fine not less than $25 or more than $50. Texas law expressly authorizes any peace officer to arrest without warrant a person found committing a violation of these seatbelt laws, although it permits police to issue citations in lieu of an arrest. In March 1997, petitioner Gail Atwater was driving her pickup truck in Lago Vista, Texas, with her 3-year-old son and 5-year-old daughter in the front seat. None of them was wearing a seatbelt. Respondent Bart Turek, a Lago Vista police officer at the time, observed the seatbelt violations and pulled Atwater over. According to Atwater's complaint, the allegations of which we assume to be true for present purposes, Turek approached the truck and yelled something to the effect of, "We've met before," and "You're going to jail." He then called for backup and asked to see Atwater's driver's license and insurance documentation, which state law requires her to carry. When Atwater told Turek that she did not have the papers because her purse had been stolen the day before, Turek said that he had heard that story 200 times. Atwater asked to take her frightened, upset, and crying children to a friend's house nearby, but Turek told her, "You're not going anywhere." As it turned out, Atwater's friend learned what was going on and soon arrived to take charge of the children. Turek then handcuffed Atwater, placed her in his squad car, and drove her to the local police station, where booking officers had her remove her shoes, jewelry, and eyeglasses and empty her pockets. Officers took Atwater's mugshot and placed her alone in a jail cell for about 1 hour, after which she was taken before a magistrate and released on $310 bond. Atwater was charged with driving without her seatbelt fastened, failing to secure her children in seatbelts, driving without a license, and failing to provide proof of insurance. She ultimately pleaded no contest to the misdemeanor seatbelt offenses and paid a $50 fine. The other charges were dismissed. Atwater and her husband, petitioner Michael Haas, filed suit in a Texas state court under 42 U.S.C. section 1983 against Turek and respondents City of Lago Vista and Chief of Police Frank Miller. So far as concerns us, petitioners, who we will simply call Atwater, alleged that respondents, for simplicity, the city, had violated Atwater's Fourth Amendment right to be free from unreasonable seizure and sought compensatory and punitive damages. 2. In reading the Fourth Amendment, we are guided by the traditional protections against unreasonable searches and seizures afforded by the common law at the time of the framing, since an examination of the common law understanding of an officer's authority to arrest sheds light on the obviously relevant, if not entirely dispositive, consideration of what the framers of the amendment might have thought to be reasonable. Thus, the first step here is to assess whether Atwater's claim that police officers' authority to make warrantless arrests for misdemeanors was restricted at common law, whether common law is understood strictly as law judicially derived or, instead, as the whole body of law extant at the time of the framing. Atwater's specific contention is that founding-era common law rules forbade peace officers to make warrantless misdemeanor arrests except in cases of breach of the peace, a category she claims was then understood narrowly as covering only those non-felony offenses involving or tending toward violence. Although her historical argument is by no means insubstantial, it ultimately fails. We begin with the state of pre-founding English common law and find that, even after making some allowance for variations in the common law usage of the term breach of the peace, the founding era common law rules were not nearly as clear as Atwater claims. On the contrary, the common law commentators, as well as the sparsely reported cases, reached divergent conclusions with respect to officers' warrantless misdemeanor arrest power. Moreover, in the years leading up to American independence, Parliament repeatedly extended express warrantless arrest authority to cover misdemeanor-level offenses not amounting to or involving any violent breach of the peace. The court reviewed in detail English common law decisions. We find disagreement, not unanimity, among both the common law jurists and the text writers who sought to pull the cases together and summarize accepted practice. Having reviewed the relevant English decisions, as well as English and colonial American legal treatises, legal dictionaries, and procedure manuals, we simply are not convinced that Atwater is correct, or even necessarily the better, reading of the common law history. A second and equally serious problem for Atwater's historical argument is posed by the divers statutes enacted by Parliament well before this republic's founding that authorizes warrantless misdemeanor arrests without reference to violence or turmoil. An examination of specifically American evidence is to the same effect. Neither the history of the framing era nor subsequent legal development indicates that the Fourth Amendment was originally understood or has traditionally been to embrace Atwater's position. To begin with, Atwater has cited no particular evidence that those who framed and ratified the Fourth Amendment sought to limit peace officers' warrantless misdemeanor arrest authority to instances of actual breach of the peace, and our own review of the recent and respected compilations of framing-era documentary history has likewise failed to reveal any such design. Nor have we found in any of the modern historical accounts of the Fourth Amendment's adoption any substantial indication that the framers intended such a restriction. Indeed, to the extent these modern histories address the issue, their conclusions are to the contrary. The evidence of actual practice also counsels against Atwater's position. During the period leading up and surrounding the framing of the Bill of Rights, colonial and state legislatures, like Parliament before them, regularly authorized local peace officers to make warrantless misdemeanor arrests without conditioning statutory authority on breach of the peace. Nor does Atwater's argument from tradition pick any steam from the historical record as it has unfolded since the framing, there being no indication that her claimed rule has ever become woven into the fabric of American law. The story, on the contrary, is of 2 centuries of uninterrupted and largely unchallenged state and federal practice permitting warrantless arrests for misdemeanors not amounting to or involving breach of the peace. Small wonder, then, that today's statutes in all 50 states and the District of Columbia permit warrantless misdemeanor arrests by at least some, if not all, peace officers without requiring any breach of the peace, as do a host of congressional enactments. 3. While it is true here that history, if not unequivocal, has expressed a decided majority view that the police need not obtain an arrest warrant merely because a misdemeanor stopped short of violence or a threat of it, Atwater does not wager all on history. Instead, she asks us to mint a new rule of constitutional law on the understanding that when historical practice fails to speak conclusively to a claim grounded on the Fourth Amendment, courts are left to strike a current balance between individual and societal interests by subjecting particular contemporary circumstances to traditional standards of reasonableness. Atwater accordingly argues for a modern arrest rule, one not necessarily requiring violent breach of the peace, but nonetheless forbidding custodial arrest even upon probable cause, when conviction could not ultimately carry any jail time and when the government shows no compelling need for immediate detention. If we were to derive a rule exclusively to address the uncontested facts of this case, Atwater might prevail. She was a known and established resident of Lago Vista with no place to hide and no incentive to flee. In common sense, she would almost certainly have buckled up as a condition of driving off with a citation. In her case, the physical incidents of arrest were merely gratuitous humiliations imposed by a police officer who was, at best, exercising extremely poor judgment. Atwater's claim to live free of pointless indignity and confinement clearly outweighs anything the city can raise against it specific to her case. But we have traditionally recognized that a responsible Fourth Amendment balance is not well served by standards requiring sensitive case-by-case determinations of government need, lest every discretionary judgment in the field be converted into an occasion for constitutional review. Often enough, the Fourth Amendment has been applied on the spur and in the heat of the moment, and the object in implementing its command of reasonableness is to draw standards sufficiently clear and simple to be applied with a fair prospect of surviving judicial second-guessing months and years after an arrest or search is made. Courts attempting to strike a reasonable Fourth Amendment balance thus credit the government's side with an essential interest in readily administrable rules. At first glance, Atwater's argument may seem to respect the values of clarity and simplicity so far as she claims that the Fourth Amendment generally forbids warrantless arrests for minor crimes not accompanied by violence or some demonstrable threat of it, whether minor crime be defined as a fine-only traffic offense, a fine-only offense more generally, or a misdemeanor. But the claim is not ultimately so simple, nor could it be, for complications arise the moment we begin to think about the possible applications of the several criteria. Atwater proposes for drawing a line between minor crimes with limited arrest authority and others not so restricted. One line she suggests might be between jailable and fine-only offenses, between those for which conviction could result in commitment and those for which it could not. The trouble with this distinction, of course, is that an officer on the street might not be able to tell. It is not merely that we cannot expect every police officer to know the details of frequently complex penalty schemes, but that penalties for ostensibly identical conduct can vary on account of facts difficult, if not impossible, to know at the scene of an arrest. Is this the first offense, or is the suspect a repeat offender? Is the weight of the marijuana a gram above or a gram below the fine-only line? Where conduct could implicate more than one criminal prohibition, which one will the district attorney ultimately decide to charge on? And so on. But Atwater's refinements would not end there. She represents, if the line were drawn at non-jailable traffic offenses, her proposed limitation should be qualified by a proviso authorizing warrantless arrests where necessary for enforcement of the traffic laws or when an offense would otherwise continue and pose a danger to others on the road, where the line drawn at misdemeanors generally, a comparable qualification would presumably apply. The proviso only compounds the difficulties. Would, for instance, either exception apply to speeding? But is it not fair to expect that a chronic speeder will speed again despite a citation in his pocket? And should that not qualify as showing that the offense would continue under Atwater's rule? And why, as a constitutional matter, should we assume that only reckless driving will pose a danger to others on the road, while speeding will not? There is no need for more examples to show that Atwater's general rule and limiting proviso promise very little in the way of administrability. It is no answer that the police routinely make judgments on grounds like risk of immediate repetition. They surely do and should. But there is a world of difference between making that judgment and choosing between the discretionary leniency of a summons in place of a clearly lawful arrest and making the same judgment when the question of the lawfulness of the warrantless arrest itself. It is the difference between no basis for legal action challenging the discretionary judgment, on the one hand, and the prospect of evidentiary exclusion or, as here, personal Section 1983 liability for the misapplication of a constitutional standard, on the other. Atwater's rule, therefore, would not only place police in an almost impossible spot, but would guarantee increased litigation over many of the arrests that would occur. For all these reasons, Atwater's various distinctions between permissible and impermissible arrests for minor crimes strikes us as very unsatisfactory lines to require police officers to draw on a moment's notice. Accordingly, we confirm today what our prior cases have intimated. The standard of probable cause applies to all arrests without the need to balance the interests and circumstances involved in the particular situations. If an officer has probable cause to believe that an individual has committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender. Atwater's arrest satisfied constitutional requirements. There is no dispute that Officer Turek had probable cause to believe that Atwater had committed a crime in his presence. She admits that neither she nor her children were wearing seatbelts as required. Turek was accordingly authorized, not required, but authorized, to make a custodial arrest without balancing cost and benefits or determining whether or not Atwater's arrest was in some sense necessary.